Well, welcome everyone. Thank you so much for joining us today. We have a wonderful speaker for our Wednesday Connect series. If you are not familiar with our Wednesday Connect program and series, it happens almost every Wednesday. Sometimes we don't have a speaker on Wednesdays, but we try to keep it consistent, and we have wonderful speakers from all over to share a little bit. Hopefully you walk away feeling a little bit more connected, a little bit more informed, and being part of the community. So thank you again to Tara Cheever for being here today. Today's program is going to be on life and legacy planning, which is a very important topic for all of us to discuss. I know a lot of times we don't want to think about it or discuss it, but it's super important for all of us to really be informed. And so before I tell you a little bit more about Tara, I just want to remind you that in order to find out about other programs that we have going on at the community center, please visit our website. It's ljcommunitycenter.org. There you can find other speakers for Wednesday Connect, for our Distinguished Speaker Series, and for weekly classes. So I hope that you visit us there. And without further ado, I'm going to tell you a little bit more about Tara. Tara Cheever attended the University of Illinois and earned a Bachelor of Science with high honors. Thereafter, she moved to San Diego to attend Thomas Jefferson School of Law, earning a Juris Doctor and graduating cum laude in 2006. While in law school, she served as a certified law clerk with the California Department of Justice, Attorney General's Office, where she wrote multiple appellate briefs and presented oral arguments for all three divisions of the 4th District on behalf of the state. Shortly after graduating cum laude, she was sworn into the California State Bar and began her career as a deputy city attorney, practicing municipal law with distinction. Having the passion to work with individuals and families in a collaborative and advisory capacity led her to launch Cheever Law, APC, where she has been serving families with their estate planning needs since 2009. Tara is involved in community service, donates to charitable organizations, and has volunteered with the San Diego Volunteer Law Program. She is passionate about living a healthy and holistic lifestyle and enjoys playing with her rescued dog, Leo, practicing yoga and Qigong, hiking, and gardening. So please help me welcome Tara Cheever.
Thank you very, very much for that introduction. I'm very kind to invite me to today's Connect series. And so I look forward to connecting with all of you. I have a little bit of a video delay. So if I need to pause my video, then I will do so if it's distracting. So before we get started, I'm going to go ahead and see if I could share my screen. So welcome everybody. I really appreciate you taking the time out of your day to be here today. And I would love for this to be an interactive opportunity. So if you want to engage in the chat, that would be great. And I'm going to be sharing a Google Sheet. If I'm able to, it's your ticket to getting all of your questions answered about specific and unique needs. So what we're going to be talking today about is life and legacy planning. So planning for a lifetime of protection, guidance, and love, and how to not go broke paying for long-term care for yourself or for your parents. So I'm very glad that you're here. Today you will learn what you need to have the peace of mind knowing that you've made the right decisions for yourself and your family during your lifetime, so that in the event of your incapacity and in the event of your death, things are as easy as possible for the people that you love. So before we get started, I want to bring into mind the people that you love and who would be impacted by your incapacity and your death. So I know that you must care about the people in your life, because no one attends a presentation on estate planning just for fun. And so you must be doing it for love. So if you could, so I'd like to get to know those people. So and their role in the role that they have in your life. So if you could share with me in the chat, their names and their role in your life. Is it your daughter or your son? Is it your partner or your spouse? Is it your parents? Is it your chosen family and the version of friends? And who will be in that role of having to figure things out when something happens to you? So let's honor them first, because they are why you're here today. So I am not seeing the chat.
Tara, I can read them for you. one of the attendees said 1 daughter and 3 sons.
Okay, great. So now that we know why you are here, so let's take a look at the let's look at the situations in which you might be in. You might either already have a plan in place, but maybe it hasn't been reviewed in a while, or maybe you don't even have a plan at all, but the state has a plan for you. And so which of those 2 categories is true for you? So go ahead and enter that in the chat. Either you have no plan at all, or you maybe have a plan, it hasn't been reviewed in a while. So actually I do see the chat now. And so if you have a plan, oops, this is, yeah, there it is. So if you have a plan, you probably had the typical experience that most people have when putting their estate plan together. So usually with the traditional, I call it the traditional experience, is a one-time transaction. You probably got some form documents. You might have seen your attorney and not really fully understood what all the ins and outs were, and you just got a set of documents. Maybe they put it in a fancy binder for you and you might have put it on a shelf. And that was kind of maybe the extent of it. To illustrate the typical experience, one of my mentors shared this story about her family. Her father-in-law needed to do some estate planning, and she hired one of the best law firms in Florida to do so. He was living in Florida. He was divorced and wanted to protect the family from conflict with his ex-spouse and didn't want any court proceedings. And so put a plan in place, spent about $4,000, got a set of form documents. He put it on a shelf. He didn't look at it again. He told his family that everything was taken care of. They didn't need to worry. And ultimately, when he passed away a couple of years later, the family was stuck in court. They were stuck in conflict with the ex-wife. And they were really upset. How could this be? We spent this money on the estate plan. And unfortunately, that's a very common scenario because the plan has not been updated. It wasn't done the right way to begin with. The client wasn't fully educated on what exactly the trust means and how it works in order to avoid problems down the road. So it didn't avoid probate. It didn't avoid, the heirs being unprotected. So with a typical experience, there's this no ongoing legal guidance. There's the potential loss of your assets to the State Department of Unclaimed Property. So in fact, this is the typical experience. This is actually a snapshot of the assets that got stuck in the State Department of Unclaimed Property that the family it's too difficult to even access at this point. In California, we have over $9 billion, that's with a B, in the state controller's office. It's the Department of Unclaimed Property. Most of the property got there because someone passed away, their family didn't know what they had, because they either did not have a plan in place or the estate plan actually failed, and those assets are simply lost to the state. So if you were hearing this story and are concerned about the assets that could be lost because you didn't have the assets inventoried, your family doesn't know where they are, you go ahead and enter them in the chat, that you need to inventory your assets. So bottom line here is that a plan is destined to fail, like the story that I shared, if it's not kept up to date and the assets aren't owned the right way. You haven't seen your lawyer since the plan was created. It might have been just a set of form documents and they sent you on your way with a binder and it hasn't been looked at since. So in that case, there's a good chance that your plan needs to be updated. So you could go ahead and put that in the chat. My plan needs to be updated. I see that Carolyn, you have a plan that needs to be updated. Barbara, you have a plan. Eleanor, you have a trust and a will, but it hasn't been reviewed in a while. So that's, very common scenario. And so I'm here to tell you today that the family actually could have a plan in place that will actually work, stay out of court, stay out of conflict, and to protect your assets from ending up in the hands of the government. So you understand how the planning works and that you feel more confident and secure in your planning. So I'm going to share with you more before we complete today about the process and how I support you to have the right plan in place for yourself and the people that you love. But for now, I'll just say that our process is not just planning for death, because what you have is a lot of life left. And so I really call it planning for life. And that's really what this is all about. So planning for life is making informed, empowered decisions about your plan and saving your family thousands of dollars or even tens of thousands of dollars in long-term care costs, assets that are not lost upon your death, protecting your family from predators, a lifetime of the right legal and financial choices, keeping your family out of court and out of conflict. So let's cover this, what happens if you don't have a plan in place. So I talked a little bit about if you have a plan, but it hasn't been updated in a while, there's a chance that it could fail, a chance that it could still end up in probate, a chance that the family could be in conflict or assets get lost. But let's talk about what happens if you don't have a plan in place at all. And then this also applies for if you have a plan that hasn't been updated. And in that situation, we have a plan that the state has for you, and that is called probate or a guardianship in the event of incapacity. So the state has an estate plan for you, and it's going to involve a judge appointing someone to make decisions on your behalf or giving your family access to the assets or direct on where your assets are going to go. The court process is called a guardianship in the event of incapacity, and it's in the event that you've passed away, then it's probate. The court decides where your money goes, and it may not be who you had originally wanted. So court is very costly. As you can see from this little diagram, there's attorney's fees and executor fees, there's appraisal fees, there's court filing fees, bond premiums, creditor claims. So let's suppose that you have an estate size of approximately 1 million. So that may sound like a lot of money, but in California, if you have a home here in San Diego County, you could easily be at that 1 million mark. If you add your home, couple bank accounts, brokerage account, you could easily be at that 1 million marker or more. So let's just say for purposes of this example that we have an estate size of about 1 million. And the statutory attorney's fees for that $1 million probate estate alone is about $46,000. And when I talk about the size of the estate, it doesn't matter whether or not you have a mortgage or a loan on the property. So that's a very common question that I get. That's like, well, the bank owns the house and, you know, I have this or that in investments or in the bank. But when it comes to the state and when it comes to process of probate and guardianship, it's the market value of all of your assets, regardless of any debts that you have. And so with a huge fee of about $46,000 for a $1 million estate, those fees could be completely avoided by having a proper estate plan in place. And then in addition to the fees, you could see from this drain that it's just a long process. It could take a minimum of 12 to 18 months during this time. And it is very stressful for the family during that time. And so this is the will of Jackie Kennedy Onassis. So the reason why I'm putting this in here is because the court process is completely public. And that may be something that you're unaware of, meaning that anyone could go into the courthouse and pull records about what you own and how you own it and who your beneficiaries are going to be. And so this is someone who actually had a will. So if there isn't a plan, Nancy mentioned she doesn't have a plan. So if she doesn't have a plan, then the state has a plan for her. But in the situation where maybe you do have a plan and you put a will in place, but it hasn't been updated, there's a chance that the will would actually have to go through the probate system, and all of the details that you put in your will would be open for the public to see. And so you could see the wills of John Lennon, JFK, Babe Ruth, Jerry Garcia. So many people had failed estate plannings where you could actually see their will. But if you want to make sure that your family stays out of court and out of conflict and completely private, go ahead and mark in the chat, that you want to keep your family out of court and you want to keep your affairs private. And so another issue with respect to having a failed estate planning or no estate planning is what happens when beneficiaries are receiving assets outright and unprotected. So for those of you, you may have children or you may have grandchildren. So you may have adult children who have children. If there is a unexpected passing and there's assets that are going to be left to them, and a plan has not been put together or a plan that needs to be updated, the court will protect those assets up until they turn 18. But then at 18, they are now the age of majority and everything goes to them outright unprotected. And so this represents, maybe some substance abuse issues, maybe some liability by texting and driving. And those assets could get lost through litigation or a lawsuit in the event that a beneficiary receives an inheritance way too early and doesn't have any structures associated with that and could end up losing the money. So before we move on about talking about kids, so either, whether you have minor kids at home or your adult children have children, I want to tell you a story that could illustrate why children could be at risk, even if you have already named guardians in a will. So about 69% of parents have not named guardians in a will. And for those who have named guardians in a will, unfortunately, that could run into a situation where it's not quite enough. So I'm going to tell a little story that's unfortunately very, very sad, but there's definitely a way for this to have been prevented. So the Barber family, they're actually from California, husband, wife, and their 3 sons went on vacation to Arizona. And they were doing a road trip and they got into a bad car accident and both of the parents had passed away. And the 3 boys who were in the back seat, they lived. But when the authorities finally found a family member to pick them up, they actually found one of the sisters. So it was the wife's sister. And that sister decided that she should get custody of the kids and prevented any other family members from seeing the children. There was understandably a big court proceeding regarding this. Over $100,000 of court costs were spent, a year of litigation, and a huge family fight. The whole family was torn apart. The judge decided that a different sister should actually raise the boys and appointed a financial conservator over the boys' inheritance at the tune of $100 an hour. And whatever was left after, once they turned 18, they just received it outright. And it's a really sad story, and that is all preventable. So now we talked a little bit about what would happen to the minor children and the minor kids in your life, whether it's your children or your grandchildren, and a little bit about your financial assets if you become incapacitated, or if you became incapacitated. We talked about guardianship and probate. So what about what happens to you in the event of your incapacity with respect to your medical care? And so there's 2 considerations here. There's the financial considerations and the considerations around the medical component about how you want your body to be treated. And so this picture on the right, it may look familiar to you, Terry Shivo. You may remember her. She was the woman who was kept on life support for many, many years while her parents and her husband battled in court about who would take medical decisions for her. So the Terry Shivo case was a right to die case from 1990 all the way to 2005. So she was in an irreversible vegetative state. Terry had a heart attack at 26. So, she thought that she had more time. She didn't need to do her planning. So she unfortunately was left in a comatose state due to the lack of oxygen in her brain. And Terry Shivo's husband was the legal guardian at the time and argued that Shivo would not have wanted to just be left on artificial life support and wanted to remove the feeding tube. While her parents disputed it and challenged him, and it was a highly publicized, prolonged series of legal challenges that ultimately involved state and federal politicians all the way up to the level of President George Bush. And it caused a 7-year delay before Shivo's feeding tube was ultimately removed. It's a very sad situation. And so, her wishes were not turned into directives. That's really what it all comes down to. It could have been all prevented with proper directives about what she wanted for her body in the event that when she was unable to make medical decisions for herself. And so this is another situation. Jennifer on the left, hugging that woman. She was in a horrible car accident, left her in a coma. Very, very similar situation to Terry Shivo, except for her mom had taken over her care, and she actually became a ward of the state, having a conservatorship over her. And in this situation, Jennifer wanted her friend to be her healthcare agent, but she just never got around to doing her planning. And so her mom, although her mom is doing it from a place of love, it is very contrary to what Jennifer's wishes were. And it's not what she wanted for herself had she been in that situation. And the one on the right, this is Milo. Milo actually had, this is Milo's son, Greg. Milo had a power of attorney and he had healthcare directives, but unfortunately it was one of those situations where he did it himself. And for purposes of time, I won't go into the huge story, but to give a brief story about Milo is Milo was starting to get taken advantage of by his stepdaughter. And so he called his son from California to come out to help him. So his son, Greg, goes out to Arizona to help him and took his power of attorney and his healthcare documents and started to do what he thought he could do to help his father. Well, unfortunately, because the plan was drafted online and wasn't done very well to begin with, the documents were not sufficient. He was not able to help his father. So Greg ended up applying to the court for a guardianship over his father, and he was denied because he wasn't able to get a bond. And that's very common, where you have to post a bond in the courts. And unfortunately, there's a lot of situations where families can't get bonded. So the judge ended up appointing a court-appointed guardian. The court-appointed guardian had exorbitant fees, ended up removing Milo from the nice facility he was living in and moved him into a lockdown facility in order for her fees to get paid. And Greg was just so desperate to help his father, so he took him out of that facility and took him to California, and Greg was thereafter arrested and criminally charged for kidnapping. It was a very, very sad situation. And Milo has since passed away, but Greg ended up in years of litigation and trying to resolve all of this. And not sure if I'm able to share it in the chat, but there is articles about this case that you might be interested in learning more about this case. And so let's kind of turn a little bit to I mentioned long-term care. So the average long-term care is about $127,000 per year. And the cost of care causes most families to destitute themselves in order to pay for care. And a lot of times the care is kind of caught off guard and it's unexpected. It could cost about $10,000 a month. And unfortunately, you need to use up all of your assets that you work so hard for before any government benefits kick in. But there's good news about that. We could actually put planning in place that will protect those assets in the event of you needing long-term care, so you're not coming out of pocket for over $10,000 a month. But we could only protect assets if it's done in advance. And so unfortunately with estate planning, it's something that people tend to maybe not want to talk about. And it is planning that is done preventively, and it is in place in the event that it happens, in the event that it's necessary. So there's some common planning techniques that don't work. And so just dispelling a couple myths here. So before we get into the specifics of how we plan and what the next steps are, I want to address some of the things that you may have heard about that you think might work. But unfortunately, some of these things actually put the family at more risk and more worse off. So adding kids to a bank account or the deed to your home is a common strategy I see a lot. I see people putting someone as a joint owner of the property. And the reason why this is bad is because in the event that there's any type of creditor issue, any type of car accident, business problem, divorce, or anything, that asset could be claimed as an asset as part of that judgment. And then another situation is if you do need long-term care and you've simply added your kids as joint owners to the bank accounts, you have not protected those assets at all. And all you've done is that made sure that when you pass away, the assets go to them directly without any court, which is a positive thing, but there's also some negatives associated with it. So there's tax issues associated with you're losing capital gains taxes, the erasing of the capital gains taxes, and ultimately it could cost more money that way. By only signing a will, you're guaranteeing that your family will end up going to court through the probate system. Relying on trust schedules alone. When a plan is drafted, generally there's a trust schedule at the back of the trust, and relying on that trust schedule without actually properly funding the assets is a disaster. And it's a common planning technique that won't work. Drafting documents online, and then like I said, transferring the family home to the kids without proper tax advice. So the only way to keep your family out of court and have your family go with as much ease as possible is a trust. And it could include a trust. You know, it certainly will include planning that has incapacity provisions, and you'll have your power of attorney. It'll be a comprehensive plan, but generally it starts with a trust. So if you already have a will, a trust, or other estate planning documents, chances are, you know, they haven't been updated in a while since you created them. Maybe they're out of date. Maybe your life has changed. Maybe the law has changed. Maybe your assets have changed. And it's also likely that the assets are not held in the proper way. So the only foolproof way is really to have the right plan, which may include a trust and a set of documents with incapacity, retitling investment accounts, signing new signature cards at the bank, you're executing new deeds to real property, you're transferring stock ownership, you're assigning personal property, you're changing your beneficiary designations. So there's a little bit of a process associated with it, and it's more than just, you know, a set of documents. And when you create a trust, you get to choose how the assets are going to be distributed. And, some people say, okay, well, you could just go ahead and distribute everything at 18, or another common thing is 1/3 at 25, 1/3 at 30, that kind of thing, the rest at 35. But there's an even better way. So how many of you would like to have a situation where your assets will never be subject to estate taxes, could never be taken away in the event of a divorce, and it cannot be touched by creditors, and it's protected in the event of any type of lawsuits? So that they're cutting edge ways that you could put planning in place that only really knowledgeable estate planning attorneys are doing. So, and not sure if you've seen this documentary on guardians, but ultimately documents can never stand in for trusted counsel. So, there's a few documentaries right now, a few shows on that are highlighting the vulnerabilities of the guardianship system in the court system. There's I Care a Lot. I don't know if you've seen that one on Netflix. And Britney Spears there's a highlight on Britney Spears talking about the conservatorship that's on her. And then there's this one here, the guardians. So ultimately, true counsel, really walking you through the specifics of your situation and having a plan for you specifically, is really the only way of really assuring that your family is not going to end up in court and end up stuck in the court system. So I did touch on this a little bit, just wanted to mention again that their total assets in California exceed $9 billion that are assets that are lost to the State Department of Unclaimed Property. And so that happens because someone passed away, their family overlooked an insurance policy or a bank account. Maybe there wasn't a financial organization. Maybe the family just didn't know what was going on. So ultimately, it's all about having a full inventory of your assets. So I could share with you a little bit more on that, on how to properly inventory your assets. But another component of estate planning is beyond the money, is your values, your insights, your stories, your experience. So if you had to choose between the people that you love receiving your money or having, the values, insights, stories, and experience, what would you choose? A lot of people say that their non-monetary assets are what makes things so valuable, So one of my good friends, her father died in 2014, and she had a voicemail of him, and she'd listen to that voicemail over and over and over and over and over again. And one day it got deleted, and she was just so devastated and crushed. And that is why, as part of the estate planning, that what I offer is called a legacy interview. So you could share your insights, share your story, share your experience, and be recorded for your family to listen to over and over and over again. And it's just such a wonderful way to pass on that legacy. And so Kathleen is asking, what is the legal way to protect your assets 100%? Well, unfortunately, Kathleen, there is not a way to protect your assets 100%, but there's definitely ways to protect assets and limit liability. So that's where insurance comes in. That's where properly funding a trust comes in. It's also looking at your specific situation about ways to limit liability. But ultimately, if something happens, if there's an injury that you caused, not you specifically, but an injury that is caused, accident that happens, there is responsibility for that. And there is ways to, quote unquote, do asset protection, which is an advanced concept of estate planning. So there's the foundational estate planning, which is what I'm talking about here. And then there is advanced planning. And generally, when you protect assets, there is a loss of control. the more an asset is protected, there's a loss of control. When you have control over an asset, that asset is subject to a creditor. So, you have money in the bank, your insurance doesn't cover the claim that has happened, and that money could be at risk. So we could always talk, individually about your specific situation. And if there's something that you're concerned about, we could talk about, if there is a way to help you limit that liability or protect your assets. And so one size planning leaves your family at risk. So we talked a little bit about this. So documents inform produced plans, either do DIY plans or you're working with a transactional attorney that's just kind of putting together a set of form documents. It leaves a family with a big mess. There may not be preparation for future incapacity. Assets must be depleted to cover long-term care costs. With one-size-fits-all planning, your assets may not be left out of the Department of Unclaimed Property, which is the state controller's office, in the event of incapacity. If family is not aware of the assets, if your assets are not properly inventoried, if family is unaware of your assets, then there's a chance that assets could get lost at your passing. And for kids that are minors, there's the risk that they could be put in the care of strangers or someone that you wouldn't want, either temporarily or permanently, in the event that the judge appoints someone that maybe you wouldn't have otherwise chosen. And it only addresses financial issues, not really what matters most, which is that intangible property we talked about. And so just to wrap up here, so my process is the life and legacy planning session. So every plan starts here. You get more financially organized than you ever have been before, because the first step is inventorying your assets. You're making informed, empowered choices. You actually could choose your planning level based on your specific situation. And the planning levels have a fee range where you see there. Most plans kind of fall right there in the middle. You actually pick your fee based on the level that you want, not, there's no surprises. There isn't any hourly rates. It's all flat fees agreed to in advance. And then with certainty that your family will be expertly guided with love throughout your life and in the event of your incapacity. So normally a family wealth planning session is $750, but I'm going to share with you how to get that session at no cost, plus $250 off any plan that you choose. So tell you a little bit more about the life and legacy planning session. We really walk through your specific family dynamics. We look at your specific assets. We look at everyone that you love and everything that you care about. And I educate you on exactly what would happen in the event of your incapacity and at your death under your specific circumstances, under your specific family dynamics. And then depending on what would happen, you are actually in the driver's seat to determine, what exactly you would like to do, whether you want to kind of keep it the way that it is, or whether you are interested in upgrading the plan. And only if you decide that the value that you would receive exceeds the cost of the plan would you put a plan in place. And so I want to make it easy for you. So I will provide you a certificate for the life and legacy planning session. It normally costs $750 or $950 for an existing plan, a review for that existing plan, but that is waived. And then a certificate for the $250 off for your chosen plan. And I know how it is that, you may look at something you want to do, but you may not want to do it yet, or it's something you want to do in the future. And so I want to make it easy for you to do what it is that you actually do want to do. So this is a little golden ticket. So in service of that, in service of being supportive to you and moving forward with your planning, you'll basically get $1,000 value of free legal services. So the life and legacy planning session is $750, plus the credit of any planning level, which is $250 off. And so in exchange to actually booking today, you would get that $250 off plus the $750 value, the life and legacy planning. So I will see if I could go ahead and put in the chat, or if not, then maybe Nancy or Barbara could send it to you guys later, is I have a worksheet that you would fill out, and that would be your ticket to getting this gift, and just gives you some little, it gives me a little bit of information about you, and then it also identifies what it is that you're looking to accomplish, and that would be your ticket to getting the session at no cost. And then if you wanted to schedule the planning session, you would get that $250 off. And if you're not quite ready to schedule a family wealth planning session, the life and legacy planning session, we could always schedule a 15-minute phone call, and we could go over your specific situation. And I'm going to go ahead and mark in the chat a link to my scheduler. So you could go ahead and either schedule just a phone call, we could get to know each other one-on-one, or the life and legacy planning session. So is there any questions that?
If there's anyone who has an additional question, feel free to unmute, or you can use the chat function if anybody would like to do that.
I know that it is sometimes feel like a little bit on the hot seat asking a question. So maybe I could address a couple like common, if you want me to address some of these common questions. So
absolutely.
You know, like a common question is, well, how often does a plan need to be reviewed? I get that question a lot. And generally, I recommend that a plan be reviewed every 3 years. So as part of my planning that I do for my clients, I include a review of the plan every 3 years. So every 3 years, you would have a complimentary review of your plan. And so the reason why reviews are so important to be done so frequently is because things change, the laws change, your objectives may change, lots of things change. So we just want to take a look at that, have a pulse on it, and just see whether everything is still in place properly, whether everything has been funded properly, and then you're good to go. And if we realize that something does need to be updated, then we would address that as well. So where would we meet? I actually have, I offer virtual meetings. And so we would meet here on Zoom. It would just be you and I, and we would schedule the life and legacy planning session. The life and legacy planning session is, we would reserve 2 hours for that. We may not use the entire time, but we reserve 2 hours, and it's here on Zoom. And there would be, in preparation of the life and legacy planning session, there would be a little bit of pre-work that you would do as part of your ticket of getting that at no cost. And I've made it as simple as possible to do the pre-work. I have created an online assessment that it's on an SSL encrypted platform. And so you would click the answers, go through the online form, and submit it to me when it's done. And that would be my way of prepping for the meeting in order to know more about you and your specific situation. And so you would have that pre-work done, and then we would meet on Zoom. And my office is in Carlsbad, so the signing would generally be in Carlsbad. But once we get to know each other, we would determine what is the best for you and where you're located and what would work best for you. And I have office locations in Sorrento Valley and Mission Valley, and my client services director would be able to meet in the South location. So we, for the signing. And then should the beneficiary of an IRA be the trust account or 2 individuals? Well, Carolyn, that's a very good, or Caroline, it's a very good question. And that is individualized. So we would determine what your goals are and who your beneficiaries are, is it would depend on who your beneficiaries are. You wouldn't name a minor as a beneficiary of the IRA. and depending on who your chosen beneficiaries are. But generally speaking, the trust, if properly drafted, there needs to be specific provisions in the trust to be payable, that the IRA is payable to a trust. There needs to be very specific language after the Secure Act. The Secure Act is a new law that had came down, and it is really important to work with an attorney who is familiar with the Secure Act and will know how to put the right provisions in the trust to make sure that the trust could be a beneficiary of an IRA and a life insurance policy.
I was thinking about if it goes in the trust, if there's additional tax implications versus having it go straight to a beneficiary.
No, it's not really the taxes that is the issue. It's more protecting the beneficiary of having this. There's some asset protection associated with naming it through the trust. You know, it kind of depends on how much is the IRA worth, who's the beneficiary. So that is a specific thing that we would discuss at a life and legacy planning session and a follow-up funding meeting. But that's generally the case where, you know, the best way when the trust is properly drafted is to have all assets in the trust and have all retirement accounts and life insurance policies made payable to the trust.
Thank you.
You're welcome. And then do I read present living trusts? Do you mean, do I review them, the ones that you have in place? Do I read it? I think that's what you mean. And if that's the case, yes, I would read it. And that would be part of the life and legacy planning session that you would submit the trust ahead of time to me with your pre-work. So I actually could read it over and see what is written in there. And I could advise you on exactly how your trust is set up. So I could, so you actually know what you have in place, what type of trust you have in place. And if I answered your question, I hope I answered your question there.
Great, thank you, Tara. Any additional questions? Again, feel free to unmute or you can use chat.
I know this is, you know, a little bit, it could appear a little overwhelming with so much material.
Well, Tara, thank you so much. This is extremely valuable information for all of us, and what a great value you're providing with the golden ticket. So I hope everyone takes advantage of that and gets everything sorted out. It's, as you see, extremely important, and many of you already know that since you have a trust in place. Thank you again, Tara, for being here. Any last minute words for everyone, or any questions that have popped up?
I just wanted to thank everybody for your time. I know that estate planning is not something that is, you know, it may not appear warm and fuzzy, but I assure you that when planning is done the right way, it gives you so much peace of mind knowing that your plan is in place. And the family wealth planning session, which I also call the life and legacy planning session, it's really no obligation. You know, this is just an educational piece where you have the opportunity to learn exactly what is going on for your specific situation and to get to know me a little bit more one-on-one.
Well, thank you again, everyone, for joining. Tara, thank you so much for being part of our Wednesday Connect series. We really appreciate your time and all the value you've provided for us. Everyone who is in attendance, thank you again. Hope to see you back again soon. Stay safe, stay well, and hope to see you back. Take care.
Great. Thank you.
Thanks,
Bye-bye.
Nancy.
Thank you.
Thank you.